some decision has been made into law, and we have our present law. And in speaking to what Senator Ballinger said about finding the best policies, to me, the bill represents a solution that is grounded in fear, that will cause unintended consequences by the fact that you don't know really enough about the person whose behavior you are reasonably believing is causing or threatening imminent, deadly force to you, particularly if they don't even show it. So you might have unintended consequences. What doors are opened to look at somebody and make that belief that that person is threatening me? It becomes a solution that allows a private citizen to become the judge, the jury, and the executioner of somebody's behavior that you don't even know, or you may not even know. But out there in that public space or wherever that you file yourself in these 6 exceptions that where you have to have to prove that you have the no duty to retreat, the location is lawful. You go someplace and you become the judge, the jury, and the executioner. And contrast that with who would be involved. And like Senator Hendren said, I agree. And like you said, Senator Ballinger, I don't have particular statistics that I could just rattle off. I could have had some. I was kind of surprised that it came so soon. I didn't expect the agenda item to be Senate Bill 24 today, to tell you.
You've got about 60 seconds, Senator Flowers.
Okay. Bear with me, Chair. But my solution, it's to correct some of these behavioral issues that I find in my communities. And I suppose that you are trying to direct these policies toward. So that my solution would be to engage law enforcement immediately when situations arise, if there's any possibility to do that. And give law enforcement the training and the tools they need to protect and to serve and to keep people safe and alive as opposed to being killed by deadly force. Our law enforcement needs tools. Our law enforcement needs training, and we expect them to have training. And what we're saying in Senate Bill 24, we're letting the private citizen, without training, just go out there. He becomes the judge, the jury, and the executioner. We don't need no courts. We don't need no law enforcement. We got stand your ground. That is not the way that I think we should go in trying to find a solution. I thank you for your indulgence, Mr. Chair and members of the committee. I wanted to end, though, if you will allow me, 1 minute. I wanted to say, just mention to you, because this has been difficult for me, but like I said, I know you got the votes and it's gonna go out of here, you know. So, but I wanted to talk to you, Gary. Senator Stubblefield, you brought up yesterday the Bible, or Monday, or Tuesday, Bible up there at the chamber. I have a family Bible too. And I copied this out of my family Bible. And I just wanted to share this with you. That in 1883, the Howard County riots, my great-grandfather died, July 1883. My father wrote this inscription in the Bible. His name was Alonzo William Flowers. He was killed by unknown persons, and his ears were cut off for souvenirs. My grandfather, Alonzo William Flowers, he was born a couple of days later, August 4th, 1883. Posses, militia, they were fighting over land. My grandfather was in a field that was owned by our family in Hempstead County. They had a posse. White men. This is documented in the Arkansas Historical Quarterly. I didn't have time to pull the quarterly to bring it. But my grandfather's father was in the field along with his wife's brother and a 16-year-old black boy sitting up on a posted fence. And a land dispute had occurred between some other men, black men and a white man. And it ended up, the white man had encroached on the black man's land. He didn't think the black man should have the land. So, fight ensued, particularly after the white man got mad and assaulted the black man's daughter in a field. So the black man was killed. And my grandfather's father was there with his brother-in-law and this young boy preparing a coffin, a wooden coffin, for the dead black man shot by these people. They were in the field. He was engaged in his work, looking forward to his son's birth. And the posse came, unknown white men came through, just shot. Shot the 16-year-old, they say in the article, like it was a bird sitting on a fence. Shot my grandfather's father and shot his brother-in-law. But you know, we serve in my family, and my father, this came out of his Bible. I serve a mighty God. So what we do here, we do. We have choices. We have a limited number of days on earth. No matter how we leave this earth, whether we're standing our ground, or we die of complications from COVID, or we live that 70. And if we're lucky, or very blessed, maybe 80 years, maybe more. But there will be something after this life on earth, and I'm looking forward to that. I thank you, committee, for your time and your indulgence.
Senator Flowers, I have one question. What state does your son live in?
I'm not disclosing that. Why do you want to know that?
Because I know what state he lives in.
Well, please, as Senator Hickey said the other day, personal, don't mess with my son now, okay?
I was just going
Don't mess with my son.
I'm not messing with your son.
Okay, thank you. Any other questions?
He just lives in a stand-your-ground state. But
okay.
I was an instructor on use of force and trained hundreds and possibly thousands of officers with the department and other law enforcement agencies on use of force. I was also a defensive tactics instructor. I was also a range master, a chemical agents instructor, less lethal instructor, close quarter combat instructor. Was fortunate enough to participate in the World SWAT competition in 2008, the only correctional team ever invited. We placed 13th in the world that year. I was actually deployed to probably maybe less than 500 actual uses of force over my career. More importantly, I wrote the Department of Corrections use of force policy, which was based upon this statute 606 and 607 at the time of my retirement. And was responsible for teaching officers how to stay within the guidelines of the law as it exists. So I'm intimately familiar with 52606 and 52607 as written, and have some knowledge about what the words mean and what they don't mean. And I appreciate y'all for allowing me to participate in this process that is so important to our representative government. Like Ms. Morgan, I stand here today in reluctant opposition to this bill. Even as I say, Senator Ballinger, I appreciate you starting this conversation and bringing this important need to light. And yes, it is a need. The young lady from Philander Smith College made a very important point, and I'm sorry I don't have any notes to go off of, but she was talking about how the general public doesn't understand the law. Don't know what it says, don't know what these changes will mean, and it's confusing. And I'm going to say this, Arkansas has a pretty good self-defense law in 606 and 607. That standard of duty to retreat in complete safety is a pretty high standard. With that said, most people in Arkansas don't know what the law is currently. I hear time and time again that I can shoot a trespasser at my home, but in public I must run. Neither of those statements are true. As Senator Ballinger pointed out in his testimony, the real standard was the force reasonable? Were you facing a threat? Were you in fear for your life? And was your response proportional and reasonable? Unfortunately, because of words such as in your home in curtilage and duty to retreat, the public is largely confused by what they can and cannot do and what they should and should not do. I will say this, the ability to retreat is irrelevant to a lethal force incident. And that's something that we need to clarify, in my opinion. If I can truly retreat, I am not facing a deadly threat. So, incomplete safety is a very high standard that almost never comes into play, as Senator Ballinger said. I don't know of anyone that's been prosecuted for not retreating, because if you're truly facing a deadly threat, you can't run anyway. You have no choice but to defend your life. My opposition to this bill, and I'll cut to the chase, I've had conversations with many of you here. As Ms. Morgan stated, lawful presence is a very troubling term for me. What is lawful today can be unlawful tomorrow. Specifically, I want to state that this refers to the criminal trespass statute. Now, I saw the memo that Senator Ballinger passed around about the defense of this bill, and said, yes, trespassers would have to retreat. And I think his assessment was correct in that. The problem is when are you trespassing? For instance, if I am a otherwise lawful citizen that is constitutionally carrying, as many of you know, no permit is required in Arkansas to carry a weapon. And if I go into a location that has a no gun sign on the door, if I didn't see it, by the trespass law, I could potentially be trespassing, because trespass law says entering unlawfully or remaining. Now, law enforcement has typically not cited or arrested anyone unless they refuse to leave. But the statute says or, not and. So if I'm an otherwise law-abiding citizen that is faced with a deadly encounter, and it's later revealed that I went past a no-gun sign, it could be determined very easily by prosecutors that I was not lawfully present. And therefore, by removing incomplete safety from the current statute, I now have a duty to retreat, which is a scary option for me, because what we're doing is confusing citizens and dividing them based upon class and money. And they don't know if they're there lawfully. Many of us can trespass or otherwise be unlawful and not be aware of it. I'll give you an instance that will bring this point home. A friend of mine in Jonesboro was recently detained at the Embassy Suites at Arkansas State University. He was at a business meeting. That's the day the governor was there, by the way. I don't know if any of y'all attended that or not. He had a business meeting not related to the governor being there. During the course of his meeting at the Embassy Suites Hotel, one of the businessmen he was meeting with said, "Hey, I need to step outside and take a break and smoke a cigarette." My friend stepped outside with him to smoke a cigarette and continue their business meeting, and he was detained by the campus police of Arkansas State University because he was carrying a weapon. Now, the controversy in question comes into play. Was he on hotel property in their parking lot, or since it is built upon Arkansas State University property, was he in violation of 573-119, carrying a weapon without a enhanced carry permit as described in 573-322? Well, I'll tell you the outcome of it. He was detained for 2 hours. His concealed handgun carry license was pulled, and it was recommended that he face felony charges. simply for having a weapon in a hotel parking lot. Now, I want to go further with this scenario. If at some point during his stay at that hotel, he had been assaulted, or if he had saw someone that was being assaulted with a deadly threat, and he had intervened and used his weapon, by the very definition and the actions of the campus police, he would have not been lawfully present, and he would have had a duty to retreat and not be able to defend himself. And why that's so important, by removing incomplete safety from the statute, as Senator Ballinger has done in 607, the only thing that matters is you have no duty to retreat if you meet conditions 1, 2, 3, 4, 5, and 6, number 1 being lawfully present, which means since incomplete safety is removed, if you don't meet any one of those 6 criteria, you now have a duty to retreat, which also means that you must proactively show the prosecutor that you attempted to retreat or why you could not before you can claim the privilege of the statute. That's very concerning to me. Now, you're going to say, Mr. Loggins, do you know of any cases where this has happened? Do we really want citizens to face this potential next year, 2 years down the road, 3 years down the road, where because their lawful or unlawful presence is what's determining was the force justified or needed, instead of was their response reasonable and did they fear for their life? I do appreciate, Senator, the change to number 4. That was also a concern for our organization. I think that clarified the law a great deal, and what you meant and intended is now very clear, and I appreciate that change. As Ms. Morgan said, we also have an issue with page 4, where we remove the ability of another person to defend the unborn child of a pregnant mother. I know Arkansas is one of the most pro-life states in the country, a fact that I'm pretty proud of. To me, this is reducing the value of that child's life. Ms. Morgan stated that we had the ability to defend the mother if she's being attacked, but we've removed that child as a person that I'm capable of defending. What if the mother cannot? What if the mother isn't armed? I said, now I'm going to have to show prosecutors that I was defending the mother's life and not the unborn baby's life. That's troubling, and I'm not sure why we're doing that. My final concern would be on 52606, the recommended amendments that Senator Ballinger has introduced. Currently under Arkansas 52606, there is no mention of duty to retreat. There are no qualifiers under which you must do anything. Now, there are some qualifiers that says the force is justified or not, such as you're not provoking, and he covered those, and he's correct on that. But currently in 606, there is zero duty to retreat, zero. And now we have made the ability to defend ourselves against non-deadly force more restrictive, I'm afraid. Now, he's correct that it refers to 52607 and says you may not use deadly force except as provided in 52607. He's correct in that. But 52607 says you have a duty to retreat if you can do so in complete safety. So right now, there is zero verbiage mentioning duty to retreat in 606, and I'm not sure how we're helping our citizens know when and when they cannot use force to defend themselves by inserting it in that statute.